I'm Ron Reagan, an unabashed atheist, and I'm alarmed by the intrusions of religion into our secular government. That's why I'm asking you to support the Freedom from Religion Foundation, the nation's largest and most effective association of atheists and agnostics, working to keep state and church separate, just like our founding fathers intended. Please support the Freedom from Religion Foundation. Ron Reagan, lifelong atheist, not afraid of burning in the camera.
Hey, hello.
Hey.
Hi.
How you doing?
You may have seen me on campus.
Maybe I sat next to you in class, or lived down the hall from you.
Or saw you at an event in the student union.
What you may not know about me is that I don't believe in God. I don't practice religion. I'm an atheist.
I'm an atheist.
I'm a secular atheist.
I am an agnostic atheist.
I'm an atheist.
I'm an atheist. I live my life with strong secular values.
I believe in helping other people.
I believe in social justice and equality for everyone.
I believe I have one life.
And I want to make a positive impact on the world.
There are many people like me.
People like me.
People like me.
People like me.
Like me.
Like me.
Like me in your store.
The Secular Student Alliance is excited to announce our annual scholarship offerings. The application opens today and is available through August of 2021. You can learn more at secularstudents.org/scholarships.
Wonderful. I'd like to welcome everyone to our second session on Sunday. I almost forgot the day there. So we're great to have Rebecca and Elizabeth with us today from FFRF. Before we start, just want to go a couple housekeeping things. We will have the presentation and followed by some Q&A. So if you have questions and you're joining us on the Zoom, please feel free to put those in the Q&A tab and we will get those answered towards the end of the presentation. If you're on Facebook, Twitter, or YouTube, we do have staff who are watching the comments there. So if you have questions, please feel free to put those in the comments and we will get those to be answered as well. So we want to keep this as inclusive as possible. So very happy to have Rebecca and Elizabeth here today. Rebecca is the legal director for the Freedom from Religion Foundation and joined on staff since in 2008 as the first in-house staff attorney. And I like to call it the floor of attorneys over there at FFRF now. And Elizabeth is an associate counsel for FFRF, and she joined full-time as a staff attorney in January of 2013. So great long histories with the organization. And today, great to have you talking about civil rights after Bostwick and Clayton versus Clayton County. And so I love that, looking at how this case determined what the meaning of religious liberty is, and there's exemptions for civil rights and how that impacts civil rights moving forward, particularly with trans rights, and of course, the decisions of moving forward. And what we look at is as far as what's happening in the federal courts. So very glad to have both of you here with us and very much look forward to your presentation today.
Well, thank you so much for having us. Liz and I are very happy to join. The Secular Student Alliance Conference is a staff favorite at FFRF. We're always really excited to get the invitation. Everyone asks every year, when do we get to go? Who gets to go? We love the presentations. We love meeting with everyone, learning from you too. And we always leave feeling really inspired and really optimistic about our secular future. So thank you very much for having us this morning. Today, like Kevin said, we are going to be talking about the Bostock versus Clayton County decision. We're coming up on the year anniversary of that landmark ruling, which said that an employer cannot discriminate against an employee for being gay, lesbian, or transgender. So in the next half hour or so, we're going to be discussing this case. what it means, how it affects religious liberty, namely exemptions to the Civil Rights Act and the Religious Freedom Restoration Act. And we're going to talk about how it impacts civil rights moving forwards, particularly for our transgendered friends. And of course, crucial to any discussion we have right now about civil rights is a discussion on court reform. And we're going to be talking about the problem with the federal courts and current efforts for judicial reform. There will be time for Q&A. So let's get down to the nitty-gritty of the Bostock case.
Sorry, you see my screen, but I'm not where I need to be, right? I'm so sorry.
That's okay. I think everybody is very used to some hiccups with these types of presentations. So thank you for your patience.
I'm so sorry. I'm not young. Okay. What's happening here? No. Here we go. No. Am I still sharing?
No.
Okay. I promise it's going to be like 3 more seconds. Here we go. Share and present. Okay.
All right. Thank you very much. This is also an opportunity for us to feel really old with technology. So sorry. So you can go to the next slide, please. So the facts of the Bostock decision, it really came from 3 consolidated cases, Bostock versus Clayton County, Georgia, Altitude Express versus Zarda, and RG&GR Harris Funeral Homes versus the EEOC. So in each of these cases, 3 plaintiffs, Gerald Bostock, Donald Zarda, and Amy Stefans, had filed civil rights suits stemming from what amounted to the same situation. Their employer had fired them for being gay or transgender. So if you can go to the next slide. Gerald Bostock, pictured here, was a child welfare services coordinator for the juvenile court of Clayton County, Georgia. He had significant success in this position and won several national awards for his work. In 2013, he joined a gay softball team, which led to animosity at work, including adverse remarks about his sexuality. Bostock was fired shortly thereafter, allegedly for conduct unbecoming a county employee. He was unable to find another job in child welfare, but he eventually found work as a mental health counselor for a hospital. He's the only one of these 3 plaintiffs who actually lived to see the decision by the Supreme Court. Donald Zarda, pictured here in the middle, was a skydiving instructor in New York. He had fallen in love with skydiving in his 20s and was very passionate about his work. In 2010, he was abruptly fired after casually mentioning to a client that he was gay before their tandem jump. His now former employer accused him of groping and offending female students to explain the termination. He was unable to find work again in the skydiving industry and unfortunately tragically died in 2014 while base jumping in Switzerland. His lawsuit was carried on by his family. Amy Stefan's termination was the subject of a lawsuit with the EEOC. She was a funeral home director and embalmer from Detroit, Michigan. She came out to her employer as a transgender woman in 2013 and found a sense of purpose in helping and comforting families going through grief. When she came out as trans, she wrote a heartfelt letter to her colleagues explaining, quote, "I have felt imprisoned in a body that does not match my mind, and this has caused me great despair and loneliness." So 2 weeks after coming out, she was fired for wearing women's clothing to work. In her lawsuit, she asserted she was fired on the basis of sex because she failed to conform to her employer's sex gender stereotypes. Following her termination, she was unable to find work at other funeral homes in the area, and eventually her own health declined. She did not live to see the victory. Unfortunately, she passed away in May of 2020, so just a month before this decision came down, due to complications from kidney failure. So since 1964, it's been illegal to discriminate against a person in employment based on certain characteristics, including sex. Title VII of the Civil Rights Act of 1964, the statute that is at issue in this case, as many people know, forbids discrimination in the workplace on the basis of race, color, religion, sex, or national origin. Neither sexual orientation or gender identity are listed as what's known as these protected classes in the statute. Rather, sex is defined in Title VII as referred to a person's apparent biological assignment as male or female at birth. Thus, before Bostock, it was assumed that an employer could legally fire an employee for being lesbian or gay or transgender. But the question was definitely not clear. And the three cases mentioned here showed that. So the 11th Circuit, which covered Gerald's case, held that Title VII did not prohibit discrimination on the basis of sex. In other words, his termination was completely legal. The Second Circuit, where Donald Zarda was, went the other direction. They said that it does prohibit discrimination based on sexual orientation, so it was absolutely illegal to fire him. And then that brings us to the Sixth Circuit, where Ms. Stefan's case was heard, and they ruled the same as the second. It prohibits discrimination based on transgender status. So this results in what's known as a circuit split. And typically what happens with circuit splits is the federal appellate courts are coming to different conclusions, and the Supreme Court takes up these cases so that they can resolve the conflict in the courts. They need to let us know what the law is so it can be consistently applied across federal courts. So the question that goes up before the court is, does Title VII cover sexual orientation and gender identity? The employees argue yes, because sexual orientation and gender identity relate to a person's sex. A woman in their position would not have been fired for being attracted to men. The employers argue, no, that type of discrimination against sexual orientation and gender identity was not the focus of the 1964 Act. That's not what Congress intended. The focus then was to ensure that men weren't treated better than women in the workplace. And by the way, nobody ever thought to include sexual orientation or gender identity in that mix. They could have done that, but they didn't. And they haven't done that since 1964. But also to include sexual orientation and gender identity was a job for Congress and not for the court. So the case should be dismissed. But we do know that the employees win. Almost a year ago, on June 15th, 2020, the court ruled 6-3 in their favor. So it is illegal to discriminate against individuals based on sexual orientation and gender identity in the workplace. Justice Gorsuch, Trump's first appointee to the United States Supreme Court, surprised everyone when it was revealed that he was the author of this majority opinion. He was very straightforward with the question. He looked at the plain meaning and language of the statute, and he found that the answer was simple. So he wrote, "Today, we must decide whether an employer can fire someone simply for being homosexual or transgender. The answer is clear. An employee who fires an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of a different sex. Sex plays a necessary and undisguisable role in the decision, exactly what Title VII forbids." So he goes through a process that's called statutory interpretation to find the answer. And he says the answer lies not just in what the definition of sex is, but also what Title VII says about it. The statute says because of sex, which also means by reason of or on account of. In essence, it's basically a but-for test. The firing would not have happened but for the employee's sex. So here's an example that he gives. Again, very simple. He says, an employer has two employees, one's man, one's a female. If the employer fires the man because he's attracted to other men, but not the female for that same attraction, the employer is discriminating against him for the traits he finds acceptable in the woman, but not the man. He says it's impossible to discriminate in that scenario without discriminating based on the employee's sex. The gay man would have a job, but for his sex. So Justice Gorsuch, reiterates that all that matters here is whether changing the employee's sex would have yielded a different choice by the employer. The reasoning here is so simple and so rational, it's completely mind-boggling to me that it took almost 60 years to get here. It's also important to note that it's just a motivating factor, not the sole factor in the firing. So there can be other reasons. The majority opinion rejects the idea that because Congress didn't squarely address sexual orientation and transgender. Gorsuch reasons that discrimination against the LGBTQ community necessarily entails discrimination based on sex. One can't happen without the other. He also says that he's not going to go into why subsequent Congresses didn't decide to include these as protected classes under the Act. He says it could be that they thought they were included, but either way, it's not the court's job to figure that out. Also, discrimination against that community was not unanticipated. It was happening in the 1960s, and lawsuits were happening at the same time that this was being filed. I'm going to go briefly into the dissents. Alito argued that the question was not whether discrimination should be outlawed. He said it's, quote, whether Congress did that in 1964, and he concludes it absolutely, indisputably did not. He writes that this decision will have far-reaching consequences, including threats to religious freedom, free speech, and personal privacy and safety. His dissent is almost 100 pages, so it's very frightening to read that decision. Justice Kavanaugh also files a dissent, and he's a fan of letting Congress deal with protections of our constitutional rights. This seems to be a trend that he has. He dissents because he believes that the ruling was actually an amendment to the law, and that's not a job for the court, that's a job for Congress. He believes Congress and the president should be the ones changing this. He writes, quote, I fully agree that gay and lesbian Americans cannot be treated as social outcasts or as inferior in dignity and worth, but it's not his job to secure that. He further writes, quote, the responsibility to amend Title VII belongs to Congress and the president in the legislative process, not to this court. He adds, quote, when this court usurps the role of Congress, as it does today, the public understandably becomes confused about who the policymakers really are in our system of separated powers, and inevitably becomes cynical about the idea that judges make their decisions based on law rather than on personal preferences. The best way for judges to demonstrate that we are deciding cases based on the ordinary meaning of the law is to walk the walk, even in the hard cases where we might prefer a different policy outcome. And I want you to not worry. He's not completely cold-hearted, and I'm being completely sarcastic when I say that, because he ends by saying, this important victory achieved today by gay and lesbian Americans is an important victory achieved today by gay and lesbian Americans. Millions of gay and lesbian Americans have worked hard for many decades to achieve equal treatment in fact and law. They've exhibited extraordinary vision, tenacity, and grit, battling often steep odds in the legislative and judicial arenas, not to mention their daily lives. We have advanced powerful policy arguments and can take pride in today's result. But Congress, rather than the Supreme Court, should have been the source of that result. So he's just a very patronizing type of justice here. So some of the key takeaways from this decision: one, this is a broad ruling. Liz is going to go into that a little bit. It's also important to note that this is a decision based on statutory interpretation. So what it gives is a statutory right to be free from discrimination based on sex, including sexual orientation and gender identity. It is not a constitutional right to be free from that discrimination. That happened in Obergefell, the case where same-sex marriage was upheld. So Bostock then only applies to the reaches of Title VII. Though, as you're going to see when Liz presents here in a few minutes, this is going to have a lot of influence over many other areas of federal law. And it doesn't squarely address some of the things that we're seeing now, like bathroom bills, locker rooms, dress codes. Gorsuch actually says in his opinion, I'm going to leave that for another day. That's for future cases to decide. And the other thing that he decides to wait for the future is the relationship between Title VII and federal laws and constitutional provisions relating to religious freedom. And this is actually a perfect time to hand it over to Liz because she's going to discuss why we're celebrating, but why we also knew that religious liberty was going to be something that was going to hollow this victory a bit for us.
Thanks, Rebecca. So I'm going to talk a little bit about a section that Rebecca and I like to call Why We Held Our Breath after Bostock. So the Bostock decision was definitely a victory, but we, the attorneys here at FFRF, cynically were holding our breath because we knew that despite Bostock's favorable interpretation of Title VII, the case decision, like Rebecca said, was limited to interpreting whether the language on the basis of sex includes gender, identity, and sexual orientation. But the case, of course, did not address any potential religious exemptions to such an interpretation of Title VII. So we also held our breath because we knew that more decisions were coming down, continuing the court's trend of granting those types of religious exemptions from laws, just like Title VII, that protect the civil rights of LGBTQ citizens. So specifically, we knew that another case was coming down that very term, and very soon after Bostock, and the case is called Our Lady of Guadalupe. It was very likely to do exactly what we feared, which was expand religious exemptions from protective anti-discrimination laws. And of course, that's exactly what happened. So the case was Our Lady of Guadalupe v. Morrissey Baru. And the decision came down just a few weeks after the Bostock decision. And, the court handed down this decision a month later that already was starting to show the limits of what was decided in Bostock. So the Our Lady of Guadalupe decision involved two, like Bostock, consolidated cases. And both of them were dealing with what's called the ministerial exception to civil rights laws. And this allows religious organizations to fire their ministerial employees for any reason, even reasons that are prohibited by law, like on the basis of race, sex, or other protected statuses under the law. So it's basically a court-created exemption from laws that otherwise would prohibit such a discriminatory firing. So the First Amendment doesn't allow the government to get involved with internal management decisions of religious institutions. So, for example, a church can fire its own pastor, its own minister. The government does not want to get involved in that dispute, even under employment laws. So the question becomes, who is a ministerial employee? Who is a minister in a religious organization? And if the employee that's being fired is found to be a minister under the law, then they're in an exception to whatever the employment anti-discrimination protection at issue is. So in Our Lady of Guadalupe, for example, the plaintiffs were two teachers at Catholic schools in California, and they were claiming a discriminatory firing. So Agnes Morrissey Baru, the name caption sake of the case was a 5th, 6th grade teacher who taught all subjects. She was not a practicing Catholic, but she taught at a Catholic school. After 16 years there as a teacher, she was replaced by a younger teacher and her contract was not renewed. And so she was suing her employer for age discrimination under the law. And the school basically claimed she couldn't perform the work, a new reading writing program. And then another plaintiff was Kristen Beale, a 5th grade teacher at St. James School in LA. She was found out that she had breast cancer and requested a leave of absence to have surgery and to recover and have treatment. And the school decided not to renew her contract. And so she sued for disability discrimination. She sadly died before the conclusion of the case, and it was carried on by her husband after her death. So both of these teachers won the right to continue their employment discrimination suits at the 9th Circuit Court of Appeals. The schools appealed to the Supreme Court, which took the case, which is never a good sign. And so fast forward to a few weeks after Bostock, the court ruled 7-2 that the Catholic schools could discriminate against these teachers and be protected from being sued. In other words, these employment discrimination lawsuits are dismissed, and these employees who were fired for these discriminatory reasons have no legal recourse. The court found that these teachers are ministers for the purpose of the ministerial exemption from employment discrimination laws. The court decided that what matters most is the religious institution's explanation of the role of the employee. So the employer, the religious institution, the way that they describe the role and how essential it is to the religious mission of their organization is what the court will somewhat defer to in deciding whether an employee is a minister and can't sue for discrimination. And in this case, the schools saw the teachers as ministers, even when they taught secular subjects. So Alito, writer of the 100-page dissent in Bostock, who was not happy about Title VII protecting LGBTQ people, he wrote the opinion in Our Lady of Guadalupe. So he basically said that religious education and the formation of students in a religious school is, the whole essence of private religious schools. And so judicial review of that in any way really violates the First Amendment. And then this is a quote up on screen, which is when a school with a religious mission entrusts a teacher with the responsibility of educating and forming students in faith, judicial intervention into disputes between the school and the teacher threatens the school's independence in a way the First Amendment does not allow. So you see, the court here is deferring so much to the school in that it is allowing the school to handle hiring and firing however it wants to, without regard to laws that protect other employees that don't work at religious institutions from discrimination. And so Sotomayor dissented, of course, and our RBG joined. This was before her death. And in her opinion, Sotomayor flagged the obvious, which is that this ruling allows religious entities to discriminate against employees just broadly, and that it'll have wide-ranging implications for so many employees. And so she says here, in her opinion, it gives an employer free rein to discriminate because of race, sex, pregnancy, age, disability, or other traits protected by law when selecting or firing their ministers, even when the discrimination is wholly unrelated to the employer's religious beliefs or practices. That's obviously true in this case, where we had an age discrimination case and a disability discrimination case, firing a teacher who needs medical leave. Doesn't seem related to the employer's religious practices, but nevertheless, they can't be sued for discrimination. She also said, got to quote Sotomayor as much as possible here, pointing out how ripe for abuse this decision really is. And as she points out, over 100,000 secular teachers' rights are at risk. And that says nothing of the countless coaches, camp counselors, nurses, social service workers, in-house lawyers, media relations personnel, and many, many others who work for religious institutions. Religious employers employ a lot of people, and all of those people, the practical effect is all of those people have almost no protections under the law against employment discrimination, which means they can be fired for being old, disabled, gay, trans, or almost any other reason. And unlike other citizens, they have no legal recourse when that happens to them. And conversely, religious employers, unlike every other employer, can discriminate against employees with legal impunity. So another case that we knew was coming down, or that was taken the following term after Bostock. It was argued this term, and the decision is actually coming possibly tomorrow, but definitely sometime this summer. The case is called Fulton versus City of Philadelphia, and many of you may have heard about this case. It's really important, and it's probably gonna go badly and further this really alarming trend towards religious privilege. The case involved Catholic Social Services, which is one of 30 agencies in Philly that contracts with the city, that the city contracts with to place their abused and neglected children in new homes, adoption and foster services. So the City of Philadelphia ended its contract with Catholic Social Services in 2018 because the group would not place children with LGBTQ individuals as foster parents, which violated, obviously, city law. CSS argues through the courts that it has a religious right to both contract with the city to perform government adoption services, but also discriminate against same-sex parents in its placements. So the Third Circuit, which covers Pennsylvania Court of Appeals, ruled in favor of the City of Philadelphia, noting that, quote, religious belief will not excuse compliance with general civil rights laws. But again, the Supreme Court granted review of that case, of that decision, and they heard argument on this term. Catholic Social Services is arguing that it must be allowed to discriminate because its contract with the city involves religious activities. FFRF actually filed an amicus brief in this case, and we argued what should be obvious to the court, which is that exemptions for religious groups from anti-discrimination rules governing city contracted programs would really put those groups in a favored position and create an imbalance in the constitutional rights of all of the stakeholders. So that's kind of the bad cases following Bostock that are just further expanding religious exemptions. But another kind of reason why Bostock is so limited and we're not, popping the champagne over it is that, again, like Rebecca said, it was a decision about statutory interpretation. What does the language of Title VII include? But the religious employers in that case in Bostock were not arguing, at least at the Supreme Court level, no one was arguing any religious liberty right to be exempted from whatever the interpretation of Title VII would be. And so Gorsuch, in his opinion, explicitly takes the time to acknowledge that the decision in Bostock does not say anything about whether or not employers might be exempt from complying with his interpretation of Title VII if they were to argue a religious liberty right to discriminate. So he's quoted in the opinion, in his majority opinion in Bostock, as saying, but how these doctrines protecting religious liberty interact with Title VII. And the doctrines he's talking about are the Free Exercise Clause and the Religious Freedom Restoration Act, which I'll describe a little more in a minute. But he's saying these questions are questions for future cases. No religious liberty claim is now before us. So while other employers in other cases may raise free exercise arguments that merit careful consideration, none of the employers before us today represent that compliance with Title VII will infringe on their religious liberties. In other words, this is a big open door for future cases or future religious actors to continue to argue that they should be exempt from Title VII or any other law that protects LGBTQ people from discrimination based on religious liberty. And we're already seeing this in the courts. One example just happened in January of 2021. A North Dakota federal court ruled exactly this, that a collective of Catholic medical providers were not required to provide services to LGBTQ people as required by a post-Bostock interpretation of the relevant law, because it would violate their rights under the Free Exercise Clause and RFRA. That was a district court, a trial level federal court, and we'll see how those exemptions kind of work their way up through the appeals courts. But we are going to continue to see a flood of religious institutions making these arguments in court now that all federal laws and regulations prohibiting sex-based discrimination are going to include protections based on sexual orientation and gender identity. So what have we seen happen since Bostock that is or will have an impact on the lives of LGBTQ Americans? And so I'm going to talk a little bit about the positives, which mostly have consisted in, since Bostock was decided, the Biden administration's protections, either through executive orders or memos within federal government departments that acknowledge and extend the Bostock interpretation of Title VII to all of these other areas of federal law, which is really positive. And here are a few of the really significant examples. So on January 20th of 2021, also known as his first day in office, President Biden issued an executive order implementing the Supreme Court's ruling in Bostock, basically making clear that the Bostock interpretation of Title VII, which means discrimination on the basis of sex, includes gender identity and sexual orientation, that would extend to all federal laws and all federal regulations that prohibit sex discrimination, not just Title VII. So that has a sweeping impact, as you can see kind of on the rest of this timeline. It applies to federal laws that concern education, housing, healthcare. On February 11th of 2021, basically implementing in the Housing and Urban Development Office, the EO from January, HUD basically issued a memo saying that discrimination on the basis of sexual orientation and gender identity is now prohibited in the Fair Housing Act. So that's a big deal, because that means people can't be treated differently for their sexual orientation or gender identity in renting, selling, pricing, eviction, service provisions, shelter access, homeowners insurance, mortgage lending, and other activities, along with harassment in the Fair Housing Act. On March 16th, the CFPB, the Consumer Financial Protection Bureau, also issued an interpretive rule clarifying that the prohibition against sex discrimination in the Equal Credit Opportunity Act applies to sexual orientation and gender identity. So that means differential treatment in credit transactions is prohibited. LGBTQ people can't be discriminated against in mortgage loans, denied car loans, credit cards, student loans, small business loans due to their sexual orientation or gender identity. March 26th, the DOJ issued a memo confirming that Bostock applies to Title IX of the Education Amendments of 1972, which means that LGBTQ students are protected from sex discrimination. That's a crucial step, protecting LGBTQ students from discrimination and harassment in schools, because it applies to any education programs or activities that receive federal dollars, which is all schools. And then we saw on, can't see my own date, but it was recently, May of 2021, HHS restored protections that were in place when President Obama was in office that made it clear that LGBTQ individuals are protected under the Affordable Care Act from discrimination in healthcare provision. And so that now, again, includes gender identity, sexual orientation in healthcare discrimination rights. So these are all some really positive things that we saw right away flowing from Bostock that all involved executive action or executive departmental action and are really positive, but is not a substitute for congressional action, which we'll talk about later. The obvious negatives have been, in the year since Bostock was decided, a new wave of state legislative transphobia. And so because Bostock expanded anti-trans protections, state lawmakers have redoubled their obsessive efforts in passing laws that really vilify and discriminate against transgender people. So we know that a few years ago, the focus was really on bathroom bills. But in 2021, the focus has moved to trans athlete bans, prohibiting, which is shameful because it targets kids, but prohibits basically trans high school athletes from playing in sports with other kids who match their gender identity. So they're very disingenuous. They're spun as protecting women's sports, which is weird because there's virtually no instances of this being a problem. And sports commissions already address these issues in a more nuanced way, which probably need improvement anyway. But also proponents of these bills do not take a general interest in women's sports or women. So it's all bogus. But you've seen since Bostock, this list of states that have passed transgender athlete bans just this year as of May 3rd. So you see Alabama, Arkansas, Florida, Mississippi, Montana, Tennessee, and West Virginia. So this is really the latest concerted effort of anti-LGBTQ state level legislation. And this one is actually being led by an all-time FFRF foe, which is called Alliance Defending Freedom. They're really powerful and really well-funded, but they're a conservative Christian legal group. We have tangled with them many times, and they are the ones behind the scenes advancing model legislation that's been used in many of these anti-trans bills. We've battled them in many of our lawsuits, and they are always fighting for Christian privilege and against LGBTQ rights. They're also a designated hate group by the Southern Poverty Law Center. So yeah, so that tells you all you need to know about these bills. But these groups and kind of entities that are pushing this backlash in anti-trans legislation is also really kind of trying to dust up opposition to what is really the long-term answer to securing LGBTQ rights in our country, which is congressional action. So the Equality Act is a piece of federal legislation that has already passed the House, but of course is doing what all legislation does in the Senate, which is sitting there dying. FFRF actually has a full-time staffer in DC who works our legislative priorities on the Hill. And one of FFRF's top priorities for legislation is the Equality Act. It provides explicit anti-discrimination protections for LGBTQ people because it amends the Civil Rights Act to prohibit discrimination based on gender identity and sexual orientation. We lobbied for the bill. We've mobilized our members to contact reps and urge them to vote for it. In 2019, it passed the House with bipartisan support. Conservative Christian politicians and groups like ADF hate it because one of its key provisions explicitly states that the Religious Freedom Restoration Act, which expands free exercise exemptions and claims, may not provide a defense to discrimination claims that are made under the Equality Act. So it secures LGBTQ rights to be free from discrimination and makes it a lot harder to argue exemptions to the law, to the Equality Act. It's a strong law that that has built-in defenses to this religious liberty just loophole to all of the anti-discrimination work that LGBTQ groups have been doing. So I am going to turn it over to Rebecca. She's going to talk about the federal courts going forward, because that's a big component in addition to congressional action, to protecting rights and expanding civil rights and anti-discrimination laws, is the federal courts. So Rebecca, you take it away.
Of course. I was muted and I started talking. So we're going to end this presentation. We wanted to end this presentation with a quick call to action for court reform. If you care at all about the future of civil rights, you need to care about the federal courts. If you care about our secular government, if you care about our government being free from religion, you need to care about the courts. We've seen that religious liberty has been an area of law where the court has huge interest, and it's also an area within the last term where the court has moved the needle the most. We've seen them take more and more religious liberty cases, and more we're seeing them move from strict separation between church and state, which actually defined the first 40 years of Establishment Clause jurisprudence, to, under Roberts, the court dismantling the wall of separation at a really rapid rate. So through the line of cases that were decided this last term, and quite possibly tomorrow or this term, we see two major trends surfacing. One is the expansion of religious privilege through increasing exemptions and a move away from separation between state and church to one of non-discrimination. Churches cannot be prevented from receiving government aid just because they're churches. What we're seeing is a rapid redefinition of religious liberty, and one where, quite frankly, Christianity is getting a favored status. They're seeking to reap these government benefits like getting aid, but also then avoiding playing by our rules. They want to get these exemptions from non-discrimination laws. And none of this is going to change in the near future, even with a friendly Biden administration. It's only going to be fueled and furthered by the impact that the Trump administration had on the federal courts. The Trump administration appointed over 200 judges, and this is nearly the same as Obama, but Trump was able to do it in half the time. He also appointed 54 appellate judges and 3 Supreme Court justices. So that all leads to a quarter of the federal bench being appointed by Trump. We released a report last year. Actually, if you could go back, thanks. We released a report at the end of last year discussing the threat of religious liberty that this judicial takeover poses. You can find the report at the link here on this slide. It will take you to the actual full report, and it also is a landing page for future monitoring and reviewing of the decisions that these judges are making. In the report, we discuss the profile of these appointments, and you are going to hear many advocates for court reform like me say that the makeup of the federal judiciary is not reflective of the makeup of the American people. And it's very true. So you can move to the next slide. These judges are often young, which is obviously very important for a lifetime appointment. They're white, they're extreme in their views. In fact, proud Christian judges and conservative legal scholars were the words of praise used by organizations when these appointments were made. And it is beyond dispute. One of their key qualifications to getting an appointment for a judgeship was a commitment to Christian nationalism. Judges that have been appointed by the Trump administration have shown increasing hostility towards the principle of separation of church and state, while jumping at every chance to exempt conservative Christians from laws that protect the rest of us. We are going to be living with this reality and these ramifications from this judicial takeover for decades to come. So everyone listening today has to become an advocate for court reform. At the end of the day, every single issue that you care about is going to be decided by the courts. So if you care about state church separation, if you care about Christianity getting greater privilege than minority religions or non-belief, particularly if you care about how that privilege affects the LGBTQ community, and if you care about true religious freedom, if you care about any of these issues at all, you need to care about court reform. So you need to get educated about these efforts. There's already a bill in Congress called the Judiciary Act of 2021. It's sponsored by a Democrat from New York named Mondaire Jones, and that bill proposes to add 4 seats to the Supreme Court. There's also a general agreement among Congress that the lower federal courts need to be expanded because they're overworked and overwhelmed with the amount of cases that they're handling. So you need to find out who your representatives are, how they feel about court reform, and what their standards are for judicial appointments. What do they look for in a judge? And let them know what you think a judge should look like and how that judge should represent you. These issues are not going to go away. The Christian nationalists are seizing on these opportunities. They have a very friendly court, and we need to be poised to fight back. We're going to continue fighting for your rights and for our secular republic and fighting for court reform. So thank you very much for joining us. We are happy to take questions right now. Our contact information is there. And please visit our website, ffrf.org, for more information. We also have a Facebook page and a Twitter account, so please follow us there as well.
Thank you so much, guys, for the presentation. Really appreciate that. There's a ton of meat in there of, I think the details of and the consecutive pattern that leading sort of up to this. And I think it's really easy in current news to see how voracious sort of the conservative Christian powerhouse is at moving a lot of these bills forward. I know Elizabeth, you sort of mentioned the stuff going on currently with trans people in sports and targeting kids. But there's also been a large wave of states looking at issues with treatment of transgender kids and getting in between the role of the physician and the patient. And I was wondering if you have anything that you can just share sort of about that and how that sort of plays in as well.
Yeah, so it's another really alarming kind of move by conservative state legislators to roll back trans rights by passing laws either at the state level or sometimes, often at the state level, to try to kind of preempt protections at the municipal level that basically either outlaw trans, treatment by doctors for transition. This actually is a really good example of why the courts are so important, because we are actually seeing that Trump judges in Florida, and there might have been a couple of other cases like this that have found, I wish I had the case in front of me, but I think Miami or some urban place in Florida had a municipal ban on conversion therapy, and it was challenged by religionists. I don't know if they were therapists or counselors, religious counselors, who wanted to be permitted to give conversion therapy. And it was a strong municipal or citywide conversion therapy ban, obviously very well backed by evidence-based harm that these types of treatments cause to our kids. And it was actually struck down by, I think it was the Florida Supreme Court, or maybe it was a panel of the 11th Circuit, but it was Trump judges, Florida Trump judges, who basically sided with the religious counselors, saying that they can't be told their religious rights and their rights to religious speech are being violated by the city that's trying to tell them that their conversion therapy is banned. So this is where we're seeing kind of like the unholy marriage of the conservative courts and the conservative legislators who are desperate to try and advance and allow rollback protections that are protections under law that are protecting our kids from conversion therapy and other horrible harm. And to pass laws that, kind of get between providers, kids, families, and their providers that are trying to, and that all evidence and science and, the actual medical associations support, but trying to get in between those decisions and kind of thwart those rights and roll them back and expand the rights of religious actors in that argument and amplify that side or kind of both sides it and make sure that we're giving, the courts are so concerned with giving like these are really private matters and we have to make sure that we're sensitive to the religious values on the one side and the secular evidence-based values on the other side. And so it's just a really good example of both the backlash and how powerful the courts are to thwart some of the progress that we're trying to make.
I'll just also tack on to that. It's just also very evident that these organizations, like Liz mentioned before, Alliance Defending Freedom, they have a lot of attorneys and they know what Bostock says. They know how broad the ruling is. So it's no coincidence that they chose these areas that Title VII does not address in order to push that. And then know that they have courts at the end of the day that are going to rule on their side. Another thing that I think, particularly with the medical treatment aspect of some of these bills, is the fact that we have a large Catholic takeover of hospitals in our country. There are a lot of hospitals that are run by the Catholic Church. And of course, as these things progress and become litigated and come into the public realm, their religious rights to refuse treatment are going to become an issue. And again, something very concerning because we've seen through Our Lady of Guadalupe that they do have these exemptions, even if they're doctors, even if they're nurses, because there's a very loose interpretation of what a minister is. Our Lady of Guadalupe said, it's basically what the employer says it is.
Right.
And so you can be a doctor at an institution not practicing Catholic, but be a minister because you're giving healthcare, which is part of Catholic doctrine in some weird, convoluted way.
And, you might be a Catholic employer, a Catholic hospital system with 10,000 employees, but yet, many of whom are not Catholic and could give, a rat's ass about Catholic doctrine. But your employer is completely exempt from employment laws that protect you as an employee. It's alarming.
I think as part of your presentation, when you were going through what some of the things that the Biden administration has done so far to sort of bolster and reinforce the protections, I think, then you had what the court and where it's going. Is part of the strategy now. I mean, I think where things are and the way the court is stacked, that a lot of the cases, I mean, I think where they're going. So is part of the strategy now, how do we just reduce as much damage as possible?
Absolutely. Yeah, I mean, they're going to use all tools that we have at our disposal to keep these protections in place and really formulate a lot of these rules and regulations in a way that they cannot be challenged, or it'll be difficult for them to be challenged in court. But our opponents have been really good at playing a long game here. And I don't think that we should stand down at all or feel that because Biden has done a lot of good for the LGBTQ community that we should just roll over and be happy that Trump's finally gone, because this is part of their strategy.
And Gordon asked, it's part of the questions is, what role does the Catholic education of the 7 Supreme Court justices play in promoting Christian supremacy over secular laws?
Yeah, not a bad question. I mean, we have is it 7? We have 7 out of 9, if you count Gorsuch, which you should, even though he's something weird. He's something like more conservative than a conservative Catholic. So it's like, 7 out of 9 Catholics. Compare that with the demographics of our nation, which I do not have in front of me, but Catholics are not that represented. So there's something just really bonkers about that when you're just thinking about representation and just ideology and background and what people are bringing to the table. But we know that there are some really conservative, dogmatic, Catholic, kind of Orthodox Catholic people on the court who their Catholic dogma has influenced the way that they feel and rule on a lot of these issues. It's a huge deal, and a lot more. You can read a lot more about this in our report on the judges. Rebecca had it on a slide, but it's ffrf.org/judicial. Judges. Sorry. Why did I go there? But yeah, I mean, it's a long answer, but I think thanks. It inevitably plays a role. I mean, of course it does. Just like representation is a massive problem throughout the federal courts. And it's not just religion, but religion is a big part of it. There's just a way over representation on conservative, religious conservative viewpoints on all of these issues.
And I think with this judicial takeover, it's important to note, as our report shows, these justices were picked because of these views. They wanted people who were conservative, Christian, uber Catholic to be on the bench to take these positions. I mean, that was a criteria. But we also need to note that one of the Catholics on the bench is Sotomayor, and she has come out swinging as one of the best dissenters. Probably will be taking the role of RBG here in standing up against this conservative bloc. But absolutely, this was the purpose of appointing these types of justices and judges to the court because of their conservative Christian beliefs. That's what they wanted there, and that's what they want the interpretation of the law to be.
And over the past few years, it hasn't just been, the focus clearly has been on the Supreme Court, but a lot of damage has also been done in the lower courts. And just as far as all the appointments that happened, and fairly conservative judges throughout that as well.
Yeah, same thing, all selected in large part by the criteria of how conservative they are on these exact issues, like anti-LGBTQ, basically, legal questions, which is religious exemptions and other exemptions to laws that expand civil rights and anti-discrimination protections. It's a big part of, and again, I'm just like constantly shilling for this report, but it goes into more depth that we don't have time to do here about the breadth of this trend in the district courts and the circuit courts of appeal, the lower courts. And that's really where so much of the damage has been done, because people just in the mold of Kavanaugh and Barrett are just totally stacking the lower courts as well.
And the volume of cases that they see versus what the Supreme Court is actually going to review. They are really the ones who are going to be deciding what's happening on the ground in your particular area, which is also why it's important. Again, I'm the show for court reform. Like, it's important to expand judges on the lower court level, which they do have the political will to do because those courts are overburdened. We've had cases at FFRF that have just lingered in different federal courts around the country, lower federal courts around the country, because there's not enough judges to handle these cases. There was one case that lingered for over a year on a pretrial motion, which is very, very unusual. Usually something like a motion to dismiss is handled fairly quickly, and we can wrap that up and then get to the meat of the matter. But some of these motions are sitting on people's dockets for an extended period of time. And so really, we need more judges just to handle the volume of cases that they're seeing.
Yeah, there's an administrative need there that, coincides with the really important, just like democratic small d need for more judges to, dilute the impact of the court packing that's been done. But I don't think they've expanded just as an administrative matter. Like, the population has grown, there's more cases, you need more people doing the work. They haven't done that, I don't think, since the 80s.
Yeah, it's been a long time.
I wonder if this is a bit of my paranoia, it's going to be a question. To me, there is a definite relationship between sex discrimination and sexual orientation and gender identity and the discrimination that's happening there. I wonder if attacking the way it's being attacked now, especially trans people, because I really think you get that differentiation between and getting back to gender discrimination. Is there a possibility or the plan moving forward for the conservative Christian community? We can attack this now, and eventually we can whittle away back at gender and sex discrimination. Am I asking that right?
Like, if you work on rolling back trans rights, eventually you can roll back
some on
everyone's rights.
On
yeah.
women's rights.
Yeah, but I think it's going to work the other way.
Okay.
It's the kind of thing where this is what's like great about America, and what sucks so bad about all of the adversaries that we're talking about is that the actual move toward, there's just like a natural inertia towards expansion of rights for people, and progress, and expanding the group of who we mean when we say you can't discriminate on the basis of sex. That we're just so. And you kind of cross that horizon. It's one of those things where it's like, it's really hard to go back on, contracting rights. That's why this religious exemption thing is like the bee's knees to these people, because it's like the one way that they have figured out to sort of like thwart the progress that's being made so rapidly that their heads are exploding. So like, marriage equality, in my opinion, is never going to contract. It's never going to be like, this court overrules Obergefell, which is saying something, because this court is terrible. They're going to overrule Roe and all this stuff. But I actually think it's really hard to contract the like expansion of civil rights, like without this sort of, I don't know what it is. It's just it's like a sham of like religious liberty exemptions and exceptions and countervailing, play in the joints between, these rights and these rights. But like, I don't see a rolling back of gay rights and women's rights just because they think, they can gain traction against the trans community. I don't know. What do you think, Rebecca?
I mean, I think it's a mixed bag, because I do think that, that's what they're doing with Roe v. Wade and all of the cases that have come from that, where they're just not necessarily contracting that right, taking it away, but they're making it so difficult to actually exercise those rights that it's virtually not there. And I can see that being very similar, especially with the Roberts Court, where Justice Roberts is so poised to maintain stare decisis. Precedent is so important. The way the institution under his reign looks is very important. And so I think that we could see this whittling away of rights under the guise of, we're really not taking away the right. We're just like putting these obstacles up that aren't really obstacles because, we decide that they're not obstacles, like it doesn't burden your right to do this because we say so. Like I see them doing that with abortion rights, reproductive rights, and I could see that happening here as well.
Yeah, I guess that's definitely a good point. There's all of these kind of sham, legal avenues, not just religious exemptions, but like states' rights and originalism, there was a question on, there's lots of avenues for the federal courts to really use its power for, putting obstacles in the way of the expansion of rights. So, all right, I tried to be optimistic and Rebecca ruined it.
Well, my optimism, Ben, would stem from just the demographics are changing. The court, again, is not reflective of where the American people are at on these issues.
On any issues.
On any issue.
Really.
And so eventually, the will of the American people will save the day. And as the younger people get older, get jobs, have families and things like that, we're going to see these shift and these just people not necessarily caring about these issues. I mean, I'm not saying it the right way, but it's not going to be playing out the way that it has been. That there's not going to be such a focus because all of those people who are focusing on it now are just going to be old and die off soon. I'm just seeing optimism in the future.
Good. Let's get, Gordon did ask us, what's the role the theory of originalism played in removing the wall of separation of church and state?
Originalism, Rebecca, there's a massive abuse of this sort of historical referencing kind of the historical practices at the time of the founders to interpret basically that they wouldn't have cared about any kind of like theocratic action by the government because, cherry pick your thing that happened at the time of the founders. There was a prayer once at the Continental Congress, and therefore they don't care about prayer at, government meetings. And so I think it's really disingenuous, but, and I don't know how much it relates to originalism in the mind of, Gorsuch or something, but I think it's kind of right up in there with like, we're going to try to harken back to what the founders intended when they wrote these words. And we're going to look at this like super cherry picked history because it's not historians who are telling us what to look at. It's just us in determining
bad historians.
Yeah. Yeah. Lawyers, not good historians. And so it plays I think it's played a huge role. If that's what we mean by originalism, I mean, that's been the undoing over the past 30 years of the separation of church and state. And Rebecca, you've witnessed the whole thing. So
yeah, no, I mean, I absolutely think that it does play a role. I do think that the justices who adopt originalism as their thing are still, in the minority. And still, I don't think they're seen as fringe any longer. Like, oh, that's just that crazy Thomas. He thinks this. I think they are becoming more mainstream, but it still is pretty a minority viewpoint. But that said, we have seen opinions come out with originalist language in it that has undermined the separation of church and state. I've seen one example is this idea that the Establishment Clause doesn't apply to the states because the Bill of Rights is just for the federal government. Something that we know is not true at all, but Thomas adheres to this view, and some of these lower court judges adhere to that view too. And in one case that I worked on out of Florida, over a cross memorial, or it wasn't even a memorial, it was just a large display of a Christian cross that they put up for Easter. But they, just sort of slyly put in the decision against us that, the Establishment Clause doesn't even apply to the city of Pensacola anyway. But the Supreme Court hasn't actually ruled that, but we think it doesn't. But, you know, that aside, here's what we've decided to make it constitutional on a different way. So these arguments are wending their way up, and they do play a role. But they're still a little bit in the minority, but I would be concerned about them.
Well, I definitely appreciate y'all's time. I could go on for asking more questions for a while, trust me. But really appreciate you being here. And FFRF has always been a great friend of the Secular Student Alliance. We know that we can always a simple call, and we know that you guys are right there for us and for our students. And all the work that you do in the federal and state work, but also the work that you do in schools all of the time that most people don't even realize, you know, that you're doing. So I just want to say thank you for that. Thank you for your time today. And really thank you for all that you do. And we'll just say, you know, there's, I think that last question, a great plug for Andrew's book. You know, I'm sure he would say, go buy it, read it. So good.
Yeah,
But
buy it on the
thank you very much.
FFRF website. Now everybody is plugged.
There you go. Yes.
Yeah. Well, we love SSA. Thank you so much for inviting us and having us in this weird format. We're still so happy to see you. And
Yeah.
thanks.
Thank you very much. Have a great day.
Thank you. Looking forward in person soon.
Yes.
Well, okay. Bye.